and social transformation in India. Question. Discuss the concept of women empowerment. Question. Explain Gandhism and Sarvodaya movement in India. Question. Power to the people has been materialized through the establishment of Panchayat Raj government. Question. How are the prisoners' rights protected under our constitution? Briefly explain. Question. Write about democratic decentralization, local self-government. Question. Question. Explain the influence of language as a divisive factor. What are constitutional guarantees given to the linguistic minorities? Question. Discuss the concept of women empowerment. The main objective behind this article is neither to favor the prevalence of feminism nor to be criticizing about the chauvinism. The focal point of this article is to promote equality. In today's scenario, the empowerment of women has become one of the most important concerns of 21st century. But practically, women empowerment is still an illusion of reality. We observe in our day-to-day life how women become victimized by various social evils. Women empowerment is the vital instrument to expand women's ability to have resources and to make strategic life choices. Empowerment of women is essentially the process of upliftment of economic, social, and political status of women, the traditionally underprivileged ones, in the society. It is the process of guarding them against all forms of violence. Women empowerment is giving legitimate power or authority to perform the tasks. Introduction. People of India used to say this country as Bharat Mata, however never realized the true meaning of it. Bharat Mata means a mother of every Indian whom we have to save and respect. Women population is around 50% of the total population of the world. Reflecting into the Vedas Purana of Indian culture, women is being worshipped such as Lakshmi Ma, goddess of wealth, Saraswati Ma, for wisdom, Durga Ma for power. Nowadays, women are increasingly gaining control over their lives and are actively taking their own decisions with regard to their education, career, profession and lifestyle. Women have demanded equality with men in matters of education, employment, inheritance, marriage, and politics, and recently in the field of religion also to serve as priest. Also, women need to be given equal opportunities for education and employment without any sense of discrimination. What is women empowerment? Women empowerment implies the ability in women to take decisions with regard to their life and work and giving equal rights to them in all spheres like personal, social, economic, political, legal and so on. We are living in an age of women empowerment where women are working shoulder to shoulder with men. A woman also manages to balance between their commitment to their profession as well as their home and family. They are playing multiple roles, at home as a mother, daughter, sister, and wife, and at working place as professionals with remarkable simplicity and compatibility. Women empowerment is essential for the betterment of any country's future as they play dual responsibilities of managing their families while simultaneously juggling to earn to contribute in fulfilling their family needs. No one can ever ignore the importance of the role of a mother, sister, or a daughter in their families. At the same time, women have also established themselves as equal contributors in managing the financial requirements of their homes. On international level as well, women have successfully created their unbeatable position, but they are just a handful in comparison to their counterparts. Women empowerment is not limited to urban, and even women in remote towns and villages are now increasingly making their voices heard loud and clear in society. While it is true that women, to a large extent, do not face discrimination in society today. Unfortunately, many of them face exploitation and harassment which can be of diverse types: emotional, physical, mental and sexual. They are often subjected to rape, abuse and other forms of physical and intellectual violence. Women are now claiming the socio-political rights, right to work, right to education, right to decide, etc., for them. The Parliament of India too has passed various legislations to save women from various forms of injustice and discrimination. To empower women there are some following laws: Equal Remuneration Act 1976, Dowry Prohibition Act 1961, Immoral Traffic Prevention Act 1956, Medical Termination of Pregnancy Act 1971, Maternity Benefit Act 1961, Commission of Sati Prevention Act 1987, Prohibition of Child Marriage Act 2006, Preconception and Prenatal Diagnostic Techniques, Regulation and Prevention of Misuse Act 1994, and Sexual Harassment of Women at Workplace Prevention, Protection and Act 2013. More recently, in the wake of Nirbhaya case involving the rape and brutal murder of paramedical student in Delhi, the government has passed the Juvenile Justice, Care and Protection of Children Bill, 2015. This act makes a significant departure from the earlier Juvenile Justice, Care and Protection of Children Act, 2000, as the juvenile age inviting punishment for offense now stands reduced from 18 to 16 years. The most famous pearl of wisdom said by the Pandit Jawaharlal Nehru is to awaken the people. It is the women who must be awakened. Once she is on the move, the family moves, the village moves, the nation moves. In India, to empower the women, first it needs to kill all the demons killing women's rights and values in the society, such as dowry system, illiteracy, sexual harassment, inequality, female infanticide and domestic violence against women, rape, prostitution, illegal trafficking and other issues. Gender discrimination in the nation brings cultural, social, economic and educational differences which push country back. The most effective remedy to kill such devils is making women empowered by ensuring the right to equality mentioned in the Article 14, Constitution of India. According to the provisions of the Constitution of India, it is a legal point to grant equality to women in the society in all spheres just like males have. The women are given a top place in India from the ancient time, however they were not given empowerment to participate in all areas. They need to be strong, aware and alert every moment for their growth and development. Empowering women is the main motto of the Development Department because an empowered mother with child makes the bright future of any nation. Position and status of women. The position and status of women all over the world has risen extraordinarily in the 20th century. We find that it has been very low in past centuries in India and hence they were treated like objects that can be bought and sold. For a long time women in India remained within the four walls of their household. They totally depend on menfolk. In India, the customs of Purdah, well system, female infanticide, child marriage, sati system, self-immolation by the women with their husbands, dowry system and the state of permanent widowhood were totally removed. It would help the innumerable women in the country who get neglected by their husbands and have no means of proving their marital status. It would also help check child marriages, bigamy and polygamy, enable women to seek maintenance and custody of their children, and widows can claim inheritance rights. The Act is applicable on all women irrespective of caste, creed or religion. It truly helps to empower Indian women to exercise their rights. Benefits of women empowerment. Women empowerment raises confidence of women in their ability to lead meaningful and purposeful lives. It eliminates their dependence on others and makes them individuals in their own right. They are able to lead their lives with dignity and freedom, which increase their self-esteem and give them a unique identity. They are able to gain recognition and form a meaningful contribution to the well-being of society. Women act as capable citizens to make the country achieve and boost gross domestic product (GDP) growth. As they are financially independent, they are able to spend on all their needs and desires, and they also get fair and equitable access to resources of the country. Necessity of women's empowerment. Without women's empowerment, we cannot remove injustice and gender bias and inequalities. If women are not empowered, they are deprived from enjoying security and protection in life. It also provides them a secure working environment. Empowerment acts as a powerful tool against exploitation and harassment of women. It is a great means to get adequate legal protection for women. If not socially and economically empowered, women cannot blossom their own identity in society, and if they are not employed, the global economy will be adversely affected, as women constitute a large extent of the world's population. As women are highly creative and intelligent, this makes it mandatory to receive their contributions in socio-economic activities. For a just and progressive society, women need to be provided equal opportunities for work. The challenges, barriers of women empowerment are the following. Because of the inherent dominance among the males, they often don't allow their female counterpart to rise as high as them. Women are bound to high level of domestic responsibilities, and they are also restricted to participate in social, economic and religious activities. In our society, preference for male child still exists, and priority for education and healthy diet given to the boy child over girl child. To overcome barriers, education through mass communication is very important. Both women and men should have aware of their responsibilities for promoting and practicing gender equality. Accumulate national data and identify the areas where occurrence of violence and gender inequality is on peak. This data can be used by the government, NGOs and field workers to increase the status of women. The society should be made aware that both boy child and girl child are equally treated, and they both should have equal access to available resources. A person may be said as powerful when he/she may have the right of particular things and also have control on a large particular portion of power resources such as knowledge, education, social status, capabilities of mobilization, personal wealth, leadership training, etc. Summit on Women Empowerment. The summit called Women Up, organized by Siahi, a literary agency, commences in October 2019. Financial independence for women is not just about being a part of the workforce. For women to be truly financially independent, it is extremely imperative for men to be active allies and equitable partners in taking up the responsibility of domestic and familiar affairs. The Women Up Summit will reflect on such crucial yet often overlooked subjects in the advancement of gender equality. Another theme that will be dwelt upon is the need for science and entrepreneurship to work together as engines of societal change. With several sessions in Hindi, the bilingual nature of the summit makes it an inclusive platform for people from all walks of life to learn and be inspired, Mita Kapoor, founder, curator and producer of Woman Up Summit said. Leading cases. In case of C.B. Muthumma v. Union of India, 1979, 4 SCC 260, 44, a writ petition was filed by Ms. Muthumma, a senior member of the Indian Foreign Service, complaining that she had been denied promotion to grade I illegally and unconstitutionally. She pointed out that several rules of the civil service were discriminatory against women. At the very threshold she was advised by the chairman of the UPSC against joining the Foreign Service. At the time of joining she was required to give an undertaking that if she married she would resign from service. Under Rule 18 of the Indian Foreign Service, Recruitment, Cadre, Seniority and Promotion, Rules, 1961, it was provided that no married woman shall be entitled as of right to be appointed to the service. Under Rule 8.2 of the Indian Foreign Service, Conduct and Discipline, Rules, 1961, a woman member of the service was required to obtain permission of the government in writing before her marriage was solemnized. At any time after the marriage she could be required to resign if the government was confirmed that her family and domestic commitments were likely to come in the way of the due and efficient discharge of her duties as a member of the service. On numerous occasions the petitioner had to face the consequences of being a woman and thus suffered discrimination, though the Constitution specifically under Article 15 prohibits discrimination on grounds of religion, race, caste, sex or place of birth, and Article 14 provides the principle of equality before law. In case of Air India v. Narjesh Mirza, 1981, 4 SCC 335, 45, Narjesh Mirza filed a writ petition. In this case, the air hostesses of the Air India International Corporation had approached the Supreme Court against, again, discriminatory service conditions in the regulations of Air India. The regulations provided that an air hostess could not get married before completing 4 years of service. Usually an air hostess was recruited at the age of 19 years and the 4-year bar against marriage meant that an air hostess could not get married until she reached the age of 23 years. If she married earlier, she had to resign, and if after 23 years she got married, she could continue as a married woman but had to resign on becoming pregnant. If an air hostess survived both these filters, she continued to serve until she reached the age of 35 years. It was alleged on behalf of the air hostesses that those provisions were discriminatory on the ground of sex, as similar provisions did not apply to male employees doing similar work. The Supreme Court upheld the first requirement that an air hostess should not marry before the completion of 4 years of service. The court held that it was a sound and salutary provision. Apart from improving the health of the employee, it helps a great deal in the promotion and boosting up of our family planning program. However, this argument given by the court came in for criticism that as the requirements of age and family planning were warranted by the population policy of the state, and once the state had fixed the age of marriage, i.e. 18 years, the reasoning advanced for upholding the rule was a camouflage for the real concern. The Supreme Court struck down the Air India regulations relating to retirement and the pregnancy bar on the services of air hostesses as unconstitutional on the ground that the conditions laid down therein were entirely unreasonable and arbitrary. The impugned Regulation 46 provided that an air hostess would retire from the service of the corporation upon attaining the age of 35 years or on marriage, if it took place within 4 years of service, or on first pregnancy, whichever occurred earlier. Under Regulation 7, the managing director was vested with absolute discretion to extend the age of retirement prescribed at 45 years. Both these regulations were struck down as violative of Article 14, which prohibits unreasonableness and arbitrariness. Legal and constitutional provisions for women in India. The principle of gender equality is enshrined in the Indian Constitution in its preamble, fundamental rights, fundamental duties and directive principles. The Constitution not only grants equality to women, but also empowers the state to adopt measures of positive discrimination in favor of women. Within the framework of a democratic polity, our laws, development policies, plans and programs have aimed at women's advancement in different spheres. Gender equality includes protection from sexual harassment and right to work with dignity, which is a universally recognized basic human right. Legal provisions. To uphold the constitutional mandate, the state has enacted various legislative measures intended to ensure equal rights, to counter social discrimination and various forms of violence and atrocities, and to provide support services especially to working women. Although women may be victims of any of the crimes such as murder, robbery, cheating, etc., the crimes, which are directed specifically against women, are characterized as crime against women. These are broadly classified under two categories. 1. The crimes identified under the Indian Penal Code, IPC. Rape, Sec 376 IPC. Kidnapping and abduction for different purposes, Sec 363 to 373. Homicide for dowry, dowry deaths or their attempts, Sec 302/304 BIPC. Torture, both mental and physical, Sec 498-A IPC. Molestation, Sec 354 IPC. Sexual harassment, Sec 509 IPC. Importation of girls, up to 21 years of age. 2. The crimes identified under the Special Laws, SLL. Although all laws are not gender-specific, the provisions of law affecting women significantly have been reviewed periodically and amendments carried out to keep pace with the emerging requirements. Some acts which have special provisions to safeguard women and their interests are the Special Marriage Act, 1954. The Hindu Marriage Act, 1955. The Maternity Benefit Act, 1961, amended in 1995. Dowry Prohibition Act, 1961. The Medical Termination of Pregnancy Act, 1971. The Equal Remuneration Act, 1976. The Prohibition of Child Marriage Act, 2006. The Criminal Law Amendment Act, 1983. Indecent Representation of Women Prohibition Act, 1986. Commission of Sati Prevention Act, 1987. The Protection of Women from Domestic Violence Act, 2005. B. Constitutional provisions. The Constitution of India not only grants equality to women but also empowers the state to adopt measures of positive discrimination in favor of women for neutralizing the cumulative socio-economic, education and political disadvantages faced by them. Fundamental rights, among others, ensure equality before the law and equal protection of law, prohibits discrimination against any citizen on grounds of religion, race, caste, sex or place of birth, and guarantee equality of opportunity to all citizens in matters relating to employment. Articles 14, 15, 15, 3, 16, 39, A, 39, B. 39, C, and 42 of the Constitution are of special importance in this regard. Constitutional privileges. Article 14, Equality before law for women. According to Article 14, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Article 15, Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 15, 1. The state shall not discrimination against any citizen on grounds only of religion, race, caste, sex, or place of birth or any of them. Article 15, 3. The state to make any special provision in favor of women and children. Article 16, Equality of opportunity in matters of public employment. Article 16, 1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 19, Freedom of speech and expression. Article 19, 1, a, states that all citizens shall have the right to freedom of speech and expression. Article 21, Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Article 39, Directive Principles of State Policy. Article 39, a. The state to direct its policy towards securing for men and women equally the right to an adequate means of livelihood. Article 39, d. Directs the state to secure equal pay for equal work for both men and women. Article 39a. To promote justice, on a basis of equal opportunity and to provide free legal aid by suitable legislation or scheme or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Article 42 of the Constitution incorporates a very important provision for the benefit of women. It directs the state to make provision for securing just and humane conditions of work and for maternity relief. Article 51, e, is related to women. It states that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religion, linguistic, regional or sectional diversities, to renounce practices derogatory to the dignity of women. Article 243d, Reservation of seats. Article 243d, 1. Seats shall be reserved for a. The scheduled castes, and b. the scheduled tribes. Article 243d, 2. Not less than one-third of the total number of seats reserved under Clause 1 shall be reserved for women belonging to the scheduled castes or, as the case may be, the scheduled tribes. Article 243d, 3. Not less than one-third, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, of the total number of seats to be filled by direct election in every panchayat to be reserved for women and such seats to be allotted by rotation to different constituencies in a panchayat. Article 243d, 4. Not less than one-third of the total number of offices of chairpersons in the panchayat at each level to be reserved for women. Article 243t, Reservation of seats. Article 243t, 3. Not less than one-third, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, Of the total number of seats to be filled by direct election in every municipality to be reserved for women and such seats to be allotted by rotation to different constituencies in a municipality. Article 243 (4) Reservation of offices of chairpersons in municipalities for the scheduled castes, the scheduled tribes and women in such manner as the legislature of a state may by law provide. See Special Initiatives for Women. 1. National Commission for Women. In January 1992, the government set up this statutory body with a specific mandate to study and monitor all matters relating to the constitutional and legal safeguards provided for women, review the existing legislation to suggest amendments wherever necessary, etc. 2. Reservation for women in local self-government. The 73rd Constitutional Amendment Acts passed in 1992 by Parliament ensure one-third of the total seats for women in all elected offices in local bodies whether in rural areas or urban areas. 3. The National Plan of Action for the Girl Child, 1991 to 2000. The plan of action is to ensure survival, protection and development of the girl child with the ultimate objective of building up a better future for the girl child. 4. National Policy for the Empowerment of Women, 2001. The Department of Women and Child Development in the Ministry of Human Resource Development has prepared a national policy for the empowerment of women in the year 2001. The goal of this policy is to bring about the advancement, development and empowerment of women in socio-economic and politico-cultural aspects, by creating in them awareness on various issues in relation to their empowerment. Government enactments. The National Commission for Women has in the last few years introduced several new bills in the Parliament from time to time towards eradication of many social evils. Some of the significant enactments are mentioned here. Beti Padhao Beti Bachao Yojana. The Dowry Prohibition Act, 1961. The Hindu Widow Remarriage Act of 1856. In the traditions at Hindu society there was a ban on widow remarriage. It was one of the most important evils from which women in the traditional Hindu society suffered a lot. This act allowed widow to remarry, and Section 5 of this act ensured her to enjoy all the rights, which a married woman did. The Child Marriage Restraint Act of 1929. The practice of child marriage was another social evil from which women in traditional Hindu society suffered a lot. Age at marriage for girls was 9 or 10, and after passing this act the minimum marriageable age of women was fixed to 15 years. Later this age was increased up to 18 years. The Hindu Marriage Act of 1955. This act has recognized the equal rights of men and women in the matters of marriage and divorce. Under the provision of this act either the man or woman, 2, can present a petition in a court of law for divorce. Wife has got equal right to divorce husband. Question. Explain Gandhism and Sarvodaya movement in India. 21st century is the era of globalization. New economic policy of globalization moves on to make the world a global village. New challenges and problems have emerged before youth. The belief that all emergent problems, ecological, social, economical, political and moral could be resolved by discoveries and technological innovations persists, features in the past notwithstanding. What is happening today is in line with what Gandhi almost predicted in Hind Swaraj as he prepared its manuscript in 1908. Gandhi put forward 4 main goals before Youth for Humanity, so as to move towards its destiny. These are Swaraj, non-violence, Swadeshi and Sarvodaya. These are the main pillars of the thesis he has propounded in the Hind Swaraj. In this paper an attempt is made to focus on Sarvodaya as one of the pillars to bring Hind Swaraj. Objectives of this research paper are to know Gandhian philosophy of Sarvodaya for changing attitude of youth and aware youth for their rights and duties. Primary and secondary resources are used for this paper. Meaning of Sarvodaya. Sarvodaya is a term meaning universal uplift or progress of all. The term was first coined by Mohandas Gandhi as the title of his 1908 translation of John Ruskin's tract on political economy, Unto This Last, and Gandhi came to use the term for the ideal of his own political philosophy. One later Gandhian, like the Indian non-violence activist Vinoba Bhave, embraced the term as a name for the social movement in post-independence India which strove to ensure that self-determination and equality reached all strata of India's society. Inspirations from Ruskin's book. Gandhi received a copy of Ruskin's Unto This Last from a British friend, Mr. Henry Pollack, while working as a lawyer in South Africa in 1904. In his autobiography, Gandhi remembers the 24-hour train ride to Durban, from when he first read the book, being so in the grip of Ruskin's ideas that he could not sleep at all. I determined to change my life in accordance with the ideals of the book. 2. Gandhi advances the concept of Sarvodaya, which were based on three basic principles. That the good of the individual is contained in the good of all. That a lawyer's work has the same value as the barber's in as much as all have the same right of earning their livelihood from their work. That is a life of labor, i.e., the life of the tiller of the soil and the handicraftsman is the life worth living. The first of these I knew. The second I had dimly realized. The third have never occurred to me. Unto This Last, made it clear as daylight for me that the second and third were contained in the first. I arose with the dawn, ready to reduce these principles to practice. Simple living and high thinking. Mahatma Gandhi was of the firm view that the earth provides enough to satisfy every man's needs, but not for every man's greed. In the Sarvodaya society of his dream, therefore, every member will be free from any greed for limitless acquisition of material wealth and more luxurious living, and they will follow the motto of simple living and high thinking. Everyone will, thus, get ample opportunity to produce and earn sufficiently through honest work for decent and dignified living. Consequently, there will be no problem of unemployment. Of course, obviously, income of different people may be different, depending on their talent, ability and effort. But those who will earn more will use the bulk of their greater earnings for the good of the society as a whole. In such a society, all wealth, including land, will be assumed as common property to be utilized for the welfare of all. If an individual has more than his proportionate portion, he becomes a trustee of the excess wealth for the benefit of the less fortunate members of the society. As regards use of machinery in economic activity, Gandhi said that, if we feel the need of machines, we certainly will have them. But there should be no place for machines that concentrate power in a few hands and turn the masses into mere machine minders, if, indeed, they do not make them unemployed. In order, therefore, to minimize use of machines in a Sarvodaya society, Gandhi strongly advocated that everyone should do some productive physical work at least to earn her daily bread, as was also advocated by Leo Tolstoy, the great Russian thinker and writer, and everyone should uphold the dignity of labor irrespective of the type of honest labor performed by an individual. Objects of Sarvodaya movement. The Sarvodaya movement has as its target the establishment of a whole network of such self-supporting village communities. The family relationships which are confined at present to the blood group will be extended to cover the whole village, where distinctions based on race, creed, caste, language and so forth will completely be eliminated. Agriculture will be so planned that all the people will have enough to consume. Industry will be conducted on a cottage basis till all the people in the village are gainfully employed. The needs of the village will be determined by the people of the village themselves, through village council, representative of the whole village. Principles of the Sarvodaya. There is no centralized authority, and there is political and economic atmosphere in the villages. Politics will not be the instrument of power but an agency of service, and Rajniti will yield place to Lokniti. All people will be imbued with the spirit of love, fraternity, truth, non-violence and self-sacrifices. Society will function on the basis on the non-violence. There will be no party system and majority rule, and society will be free from the evil of the tyranny of the majority. The Sarvodaya society is socialist in the true sense of the term. All calling will be the same moral, social and economical values. The individual personality has the fullest scope for development. The Sarvodaya society is based on equality and liberty. There is no room in it for unwholesome competition, exploitation and class hatred. Sarvodaya stands for the progress of the all. All individuals should do individual labor and follow the ideal of non-possession. Then it will be possible to realize the goal of, from each according to his work and to each according to his needs. There will be no private property, the instrument of exploitation and the source of social distinctions and hatred. Similarly, the profit motive will disappear, rent and interest too will go. The Sarvodaya movement is based on truth, non-violence and self-denial. The Sarvodaya movement makes a sincere and bold attempt to create the necessary atmosphere to bring together such individuals with an unwavering faith in the welfare of all. The gain to the individual would be small. The development of each quality depends upon every other. If all the qualities are improved a little, then the individual would gain more. Sarvodaya movement. Gandhi's ideals have lasted well beyond the achievement of one of his chief projects, Indian independence, Swaraj. His followers in India, notably, Vinoba Bhave, continued working to promote the kind of society that he envisioned, and their efforts have come to be known as the Sarvodaya movement. Anima Bose has referred to the movement's philosophy as a fuller and richer concept of people's democracy than any we have yet known. Sarvodaya workers associated with Vinoba, J.P. Narayan, Dadadhar Madhikari, Dhirendra Mazumdar, Shankar Rao Dio, K.G. Mashruwala undertook various projects aimed at encouraging popular self-organization during the 1950s and 1960s, including Gudan and Gramdan movements. Many groups descended from these networks continue to function locally in India today. 5. Agency of Common Welfare. That Sarvodaya is an agency of service for common welfare. Sarvodaya sets its face squarely against the politics of power and exploitation. It lays great emphasis on moral and spiritual values. It seeks to create new social and economical values. The concept of possession yields place to the concept of trusteeship. People will work for the good of all, and family feeling will animate the entire community. There will be fullest scope for freedom, fellowship and equality. The state is to be an agency of power. Gramrajya is a base of non-violence. Sarvodaya stands for good of all and not for the good of any particular individual or class. Gudan at the early stage, Gramdan at a later stage, and Sampatidan will bring about a change of heart. The rich and poor will give up their ideas of attachment to private property and will strive to work for the good of all. Conclusion. So, lastly we can conclude that Sarvodaya ideals are not practicable. Though the ideals of Sarvodaya will be noble. Nobody can find fault with them, in the actual world. They will be found wanting. It will be almost impossible to establish a society strictly on the basis of great principles by Mahatma Gandhi and others. Sarvodaya doctrines are soaring and it is doubtful whether they can rest on the earth. The poor record of Panchayat Raj in India bears testimony to the backward condition in which people are. In the highly competitive world, one country cannot succeed in having Gramraj. Unless all states in the world accept the Sarvodaya idea. The chances of having it is a particular country like India are bleak. As well as, it is difficult to bring a change of the heart in the youth, who is given to selfishness. People donated useless land in response to the Bhudan. Question. Power to the people has been materialized through the establishment of Panchayat Raj. Comment. The Panchayati Raj system is an Indian decentralized form of local self-government that attempts to deliver democracy to the people. The word, Panchayati Raj, literally means, ruling by the village council, and refers to the rural local government system. The Panchayati Raj system was adopted as a constitutional amendment in India in 1992 with the goal of decentralizing authority and increasing democratic participation at the grassroots level. It is a crucial component of India's democratic system since it allows local people to participate in decision-making, facilitates the delivery of services and infrastructure at the local level, and promotes accountability and openness. The Panchayati Raj system is divided into two tiers or levels, the Gram Panchayat, village council, and the Panchayat Samiti, block or taluka level council. The Gram Panchayat is in charge of a single village or set of villages, whereas the Panchayat Samiti is in charge of a group of Gram Panchayats. A third layer of Panchayati Raj institutions, known as the Jilla Parishad, District Council, has also been established in several states. The Jilla Parishad is in charge of managing district development and coordinating the operations of the lower level councils. Background. In India, the Panchayati Raj system is a decentralized type of administration aimed at bringing democracy closer to the people at the grassroots level. It changed throughout time due to different constitutional modifications and policy changes. The system may be traced back to the 1957 Balvantarai Mehta Committee report, which advocated for the development of Panchayati Raj institutions to decentralize power and promote local self-governance. However, the Panchayati Raj system was not fully recognized and given constitutional standing until the 73rd and 74th constitutional amendments of 1992. The 73rd Amendment introduced panchayats at the village, intermediate, and district levels, while the 74th Amendment introduced municipalities at the city, town, and urban agglomeration levels. These amendments provided for the direct election of members of these institutions, the reservation of seats for women and marginalized groups, and the devolution of powers to these institutions in various areas of governance. Since the introduction of the Panchayati Raj system, there have been several milestones in its development. The National Panchayati Raj Day is celebrated on April 24 each year to mark the passing of the 73rd Amendment, and several policy initiatives have been undertaken to strengthen the system. These include the Rajiv Gandhi Panchayat Sashaktikaran Abhiyan, the Panchayat Empowerment and Accountability Incentive Scheme, and the E-Panchayat Mission Mode Project. 2. Panchayati Raj System. The two-tier Panchayati Raj system is an Indian centralized governance system that involves the formation of two levels of local self-government institutions, namely Gram Panchayats and Panchayat Samitis. Gram Panchayats are the system's fundamental components, in charge of governing villages or groups of villages. Each Gram Panchayat is made up of a directly elected Sarpach, village leader, and other people elected members known as Pachas, councillors. Gram Panchayats are in charge of providing basic facilities such as water, sanitation, healthcare, and education in the community. The 73rd Amendment to the Indian Constitution, passed in 1992, established the two-tier Panchayati Raj system with the intention of advancing local democracy and giving people more control at the local level. It has contributed to increased public participation in the government process and the growth of the nation's rural areas. The system is composed of two tiers, the Gram Panchayat, village council, at the village level, and the Panchayat Samiti, block council, at the block or taluka level. Here are the roles and responsibilities of each level. Gram Panchayat. The Gram Panchayat is the lowest tier of the Panchayati Raj system and is responsible for governing a single village or group of villages. Its primary functions include planning and implementing rural development programs and schemes within its jurisdiction, maintaining and developing community assets such as roads, water supply systems, and public buildings, implementing government welfare programs such as MNREGA, ICDS, etc., resolving disputes and conflicts that arise within the village, collecting taxes and fees as authorized by the state government, maintaining records and registers of births, deaths, and marriages in the village. Panchayat Samiti. The Panchayat Samiti is the second tier of the Panchayati Raj system and covers a group of Gram Panchayats within a block or taluka. Its primary functions include coordinating the development activities of the Gram Panchayats under its jurisdiction, planning and implementing block-level development programs and schemes, providing support and guidance to the Gram Panchayats in their development activities, ensuring the effective delivery of government welfare programs at the block level, mobilizing resources for rural development activities, maintaining records and registers of births, deaths, and marriages within its jurisdiction. 3. Panchayati Raj system. It is the primary unit of local self-government at the village level. It is made up of Panchayat members, who are elected for a 5-year tenure. The Gram Panchayat is in charge of essential services like sanitation, drinking water, street lighting, and village road maintenance, among other things. It is the intermediate stage of local self-government for a group of villages. The Panchayat Samiti is in charge of planning and implementing several development projects at the block level. It is composed of delegates elected from each of the Gram Panchayats under its jurisdiction. In India, the three-tier Panchayati Raj system is a kind of decentralized government. It consists of 3 tiers of institutions for local self-government, each with unique duties and authority. Gram Panchayat, village level. The Gram Panchayat is the primary level of the Panchayati Raj system, responsible for governing and managing village-level affairs. It comprises elected representatives who oversee the development and progress of their respective villages. The Gram Panchayat is responsible for executing essential rural development programs such as sanitation, primary education, healthcare, drinking water supply, and social welfare initiatives. Additionally, it maintains accurate records of vital events such as births, deaths, and marriages occurring within the village. Panchayat Samiti, block level. Sitting between the Gram Panchayats and the Jilla Parishad, the Panchayat Samiti constitutes the intermediary tier of the Panchayati Raj system. It comprises a group of Gram Panchayats and serves as the governing body for a block or taluka encompassing multiple villages. The Panchayat Samiti plays a pivotal role in coordinating and supervising the functioning of the Gram Panchayats under its jurisdiction. Additionally, it oversees the execution of diverse rural development schemes and programs pertaining to agriculture, animal husbandry, and rural industries. Jilla Parishad, district level. At the apex of the Panchayati Raj system, the Jilla Parishad serves as the topmost tier representing the district level administration. It is composed of elected representatives from the Panchayat Samitis and shoulders the responsibility of overseeing the holistic progress and growth of the entire district. The Jilla Parishad acts as the nodal agency that coordinates and monitors the operations of the Panchayat Samitis falling within its jurisdiction. Moreover, it devises and executes a diverse range of schemes and programs catering to the district's needs concerning education, healthcare, agriculture, and rural development. Comparison between two-tier and three-tier systems. The most prevalent types of systems utilized in decentralized governance are two-tier and three-tier systems. The number of levels of government and the roles they play varied between these systems. Similarities between the two-tier and three-tier Panchayati Raj systems. Both systems aim to promote grassroots democracy and decentralize power to the local level. Both systems have elected representatives at the village or ward level. Both systems have provisions for the reservation of seats for women and marginalized communities. Differences between the two-tier and three-tier Panchayati Raj systems. The village level and the block level are the only two tiers of government in the two-tier system. The three-tier structure, on the other hand, consists of three levels: village, block, and district. Comparing the two-tier and three-tier systems, the two-tier system has fewer elected representatives. For instance, the two-tier system in Uttar Pradesh only has 2 representatives per village, but the three-tier system in Kerala has 4 representatives per village. Comparatively speaking, the two-tier system has fewer administrative duties than the three-tier structure. For instance, the block level in a two-tier system only has a small number of administrative duties, whereas, in a three-tier system, the block level is responsible for a large number of administrative duties. Advantages and disadvantages of the two-tier Panchayati Raj system. Advantages. In comparison to the three-tier system, the two-tier system is simpler and easier to implement. Due to fewer elected representatives and administrative duties, the two-tier system is more economical than the three-tier system. Local communities can participate and be more actively involved in decision-making thanks to the two-tier approach. Disadvantages. Larger states that require more decentralization of power may find the two-tier structure ineffective. When dealing with complex problems that demand a higher level of administrative competence, the two-tier structure could not be effective. Due to the lower number of elected members, the two-tier system may not be as effective in guaranteeing the equitable allocation of resources. Question: How are the prisoners' rights protected under our Constitution? Briefly explain. Every living being is born free and has equal rights. No one, including prisoners, shall not be subjected to torture or cruelty. Prisoners are also human beings and have a right to an appropriate standard of living, including food, drinking water, accommodation, clothing and comfortable bedding. The Prisons Act of 1894 was in place throughout the time of British administration in India, but the rights were consistently violated since the foreign and domestic convicts were treated differently due to prejudice. Due to the reality that a prisoner is always still a human being, the authors of the Indian Constitution decided to grant prisoners some rights when India gained independence. A prison is a location that is suitably set up for offenders to be kept in safe custody while being tried or punished. At first, it served only as a holding facility or a detention for criminals awaiting trial and the final punishment, but there came a point where incarceration gained legitimacy on its own. Earlier legislation regarding the rights of prisoners. Our present system went through a significant modification once we gained our independence in 1947. The government showed particular interest in it. A team of specialists from the United Nations were asked to examine the jail system, and it was said that they made some recommendations to improve prisoners' rights. It is shocking to see that many developed nations, including China and India, still lack legislated prisoner rights, yet our honorable judiciary has recognized a large list of these rights, and the government still continues to fight for the welfare of the inmates. Even after punishment, a prisoner continues to be a living, breathing human being. Consideration has to be such a human being since he is also a citizen of India. The right to dignity guaranteed by the Indian Constitution is not diminished by the legal restrictions placed on one's freedom. Even within bars, she or he is still entitled to basic human rights. The Prisons Act of 1894, a century-old act, had established state laws in India that control prisons. There are, however, very few states and union territories that have laws or regulations that were created in the 21st century, including the Andaman and Nicobar Islands, Arunachal Pradesh, Bihar, Daman and Diu, Delhi, Goa, Sikkim, and West Bengal. The modifications made to these state laws haven't done much to advance the body of law that, among other things, protects prisoners' rights. Articles granting rights to prisoners. Article 14. According to Article 14 of the Indian Constitution, the state shall not deny to any individual within the territory of India the equality before the law or the equal protection of the laws. As a result, Article 14 of the Indian Constitution introduced the concepts of reasonable classification and the idea that love should be treated similarly. The Constitution of India and in particular, the Article 14 and its fundamental freedoms serve as a guide and foundation for the jail authorities to identify different prisoner categories and their classifications with the goal of reformation. Human dignity is integral to human rights. In a series of rulings, the Supreme Court has expressed grave concern over the inhumane treatment of prisoners and gave the appropriate instructions to the prison and police authorities for protecting their rights. A human being's treatment that violates human dignity, subjects him to unnecessary agony, and lowers him to the status of a beast would undoubtedly be arbitrary and subject to challenge under Article 14 of the Indian Constitution. Article 19. 6 freedoms were guaranteed to all Indian people by Article 19 of the Constitution. These freedoms include, for example, the right to free speech and expression under Article 19, 1a, and the right to join an association. Just as these freedoms are available for the citizens of India, detainees also have a right to utilize them. However, the government may pose restrictions if and when required to exercise caution is the utility of such freedoms by prisoners. Article 21. No one must be deprived of their life or personal liberty, except in accordance with a legal process, according to Article 21 of the Indian Constitution. The right to life and the idea of liberty are two ideas that are outlined in this article. It is made plain by Article 21 of the Indian Constitution that it is open to both free and confined individuals. Rights of prisoners. Right to legal aid. Although the Indian Constitution does not clearly establish the right to legal aid, legal professionals frequently show generosity to prisoners who cannot pay it or who could voluntarily contact a legal advisor. The 42nd Amendment Act, 1976 lists free legal aid as one of the directive principles of state policy in Article 39A of the Indian Constitution. Although the Constitution's article on free legal aid is the most important and explicit, courts may not always have the authority to enforce it. Nonetheless, following these rules is essential to applying the right laws. According to Article 37 of the Indian Constitution, the state must follow these guidelines. Right to speedy trial. The saying, "Justice hurried is justice worried," refers to how important a speedy trial is to a fair trial. Hence, a balance must be struck between the accused's right to a swift trial and the prosecution's right to a fair opportunity to prove the accused's guilt. Article 21 of the Indian Constitution is where the idea of a fast trial originates. One of the key objectives of the criminal equity conveyance system is the expeditious trial of crimes. Immediately after the court accepts the allegation, the prosecution must be instructed to reject the guilty party and clear the innocent one. The fundamental principle of civilized criminal law is that a person is deemed innocent until they are found guilty of the charged offense. Article 14. 2. Of the 1966 International Covenant on Civil and Political Rights recognizes the presumption of innocence as a human right. According to Article 11, 1, of the 1948 Universal Declaration of Human Rights, anybody accused of a crime has the right to a public trial where they will be deemed innocent unless proven guilty in accordance with the law and will be given all the protections essential for their defense. Right to a fair trial. It wouldn't be an overestimation of things to say that a fair trial is the edifice of criminal law and, in a sense, an quintessential component of a democratic, rule of law-based society. Denying a fair trial is equivalent to crucifixion of human rights. It is ingrained in the idea of fairness in the legal system. While emphasizing the principle of a fair trial and the application of the same during the trial, it is required of the courts to determine whether, in a particular case or category of cases, reversal of the judgment of conviction due to non-compliance with a certain provision is inevitable or depends on reaching an undisputed conclusion that substantial injustice has occurred. Right to live a life with dignity. The Indian Constitution guarantees every citizen the right to live a life of dignity. The prisoners are likewise granted this privilege since their conviction does not render them inhuman. This right is a crucial component of the Indian Constitution's provision of the right to life. Every person's life is valuable, and regardless of the circumstances, they should be treated with dignity to enable them to continue living. Right to meet one's family. The scope of human rights is an ever-growing concept, and prisoners' rights have been acknowledged equally in order to spare them from both physical suffering and mental torture. The right to interview one's family and friends is unquestionably covered by the personal liberty guaranteed by Article 21 of the Indian Constitution. Prisoners ought to receive both physical and mental protection. Individuals must get together in order to exchange information. This is a basic human right. Being their legal agents, consult attorneys, make decisions that directly impact the case of the convicted. The visits from friends and family members provide them the mental stability they need to endure in such a terrible situation where no one knows each other. Right to life and personal liberty. The Honorable Supreme Court has frequently upheld the relevance of Article 21 and applied its ruling in several cases. The meaning of the word life, as used by Field J in the well-known case of Karak Singh v. State of UP, has been broadened. In the aforementioned instance, the court decided that the term life refers to more than just an animal's existence. The prohibition against its loss applies to all the limbs and faculties that are used to enjoy life. The law also forbids the destruction of any other part of the body through which the soul communicates with the body, such as an arm or a leg, an eye, or another organ. Landmark cases. In the depths of Article 21 of the Indian Constitution, the Honorable Courts of India have introduced various fundamental rights for prisoners. In the case of Sunil Batra v. Delhi Administration, it was decided upon that prisoners have the right to visits from their family members in order to protect them from mental torture and maintain mental peace. This was a landmark decision that also upheld the right of prisoners to mental health. Every person has rights that are protected by Article 21 and cannot have those rights violated, not even by the state's authority. In the case of State of Maharashtra v. Prabhakar Pandurang found that a prisoner has the right to express their feelings in writing and can publish that in the framework of the right to personal liberty. The second right is to pay fair wages to prisoners for the work they have performed while incarcerated. This has been done in numerous precedents, including Mohammad Jayasuddin v. State of AP, People's Union for Democratic Rights v. Union of India, State of Gujarat v. Honble High Court of Gujarat, and Gurudev Singh v. State of Himachal Pradesh, with the goal of enabling prisoners to lead self-sufficient lives after their release. To be specific, it was decided that compensation must be paid and should not be less than the minimum stipend. Conclusion. One of the worst groups of human beings destined to experience a clear fundamental right being violated is prisoners. The Supreme Court has reaffirmed the principle that the loss of fundamental rights does not result from imprisonment. The Supreme Court has so formally stated that a prisoner's fundamental rights remain an enforceable reality, even if they are constrained due to their incarceration. Thus, one could argue that while incarcerated, inmates are still entitled to all of their fundamental rights. Although the Indian Constitution does not openly and explicitly guarantee prisoners' rights, Articles 14, 19, and 21 do so inferentially. Moreover, the Prisons Act of 1894 has measures for the welfare and safety of prisoners. Question: Right about democratic decentralization, local self-government. What is democratic decentralization? About. Democratic decentralization is the process of devolving the functions and resources of the state from the center to the elected representatives at the lower levels so as to facilitate greater direct participation of citizens in governance. Devolution, envisioned by the Indian Constitution, is not mere delegation. It implies that precisely defined governance functions are formally assigned by law to local governments, backed by adequate transfer of a basket of financial grants and tax handles, and they are given staff so that they have the necessary wherewithal to carry out their responsibilities. Related constitutional provisions. Local government, including panchayats, is a state subject in the constitution, and consequently, the devolution of power and authority to panchayats has been left to the discretion of states. The constitution mandates that panchayats and municipalities shall be elected every 5 years and enjoins states to devolve functions and responsibilities to them through law. The 73rd and 74th Amendments, by constitutionally establishing Panchayat Raj institutions, PRIs, in India, mandated the establishment of panchayats and municipalities as elected local governments. These amendments added 2 new parts to the constitution, namely, Part 9 titled, The Panchayats, added by 73rd Amendment, and Part IXA titled, The Municipalities, added by 74th Amendment. The 11th schedule contains the powers, authority and responsibilities of panchayats. The 12th schedule contains the powers, authority and responsibilities of municipalities. Article 40, Organization of a village panchayat. What are the major achievements of the local bodies? Rising women representation. The proportion of elected women representatives has been steadily rising since the enactment of the 73rd Amendment Act. Currently, India has 260,512 panchayats with 3.1 million elected representatives, of which a record 1.3 million are women. While there is merely 7-8% representation in parliament and state assemblies for women, an astounding 49% of elected local representatives, in states like Odisha it has crossed 50%, are women. Created healthy competition among various states. The passage of the 73rd and 74th Amendments has created healthy competition among various states regarding devolution, the 3 Fs, funds, functions, and functionaries. For instance, Kerala has devolved 29 of its functions to panchayats. Rajasthan took the inspiration from Kerala to devolve many key departments such as health, education, women, and agriculture to PRIs. Similarly, Bihar came out with the idea of Panchayat Sarkar, and states such as Odisha have increased 50% seats for women. What are the issues with local governments in India? Insufficient funding. The money given to the local governments is inadequate to meet their basic requirements. A number of conditions constrain the use of money, including inflexibility in spending the allocated budget. There is little investment in enabling and strengthening local governments to raise their own taxes and user charges. Infrastructural challenges. Some of the Gram Panchayats, GPs, do not have their own building and they share space with schools, Anganwadi centers and other places. Some have their own building but without basic facilities like toilets, drinking water, and electricity connection. While GPs have internet connections, they are not functional in many cases. For any data entry purposes, Panchayat officials have to visit block development offices which delay the work. Lack of staff. Local governments do not have the staff to perform even basic tasks. Furthermore, as most staff are hired by higher level departments and placed with local governments on deputation, they do not feel responsible to the latter. They function as part of a vertically integrated departmental system. Untimely and delayed elections. States often postpone the elections and violate the constitutional mandate of 5-yearly elections to local governments. Downgraded role of local government. Local governments are merely acting as an implementation machinery rather than a policy-making body for local development. Technology-enabled schemes have further downgraded their role. Corruption. Criminal elements and contractors are attracted to local government elections, tempted by the large sums of money now flowing to them. Thus, forming a market chain of corruption operates, involving a partnership between elected representatives and officials at all levels. However, there is no evidence to show that corruption has increased due to decentralization. Way forward. Revitalization of Gram Sabhas. Gram Sabhas and wards committees in urban areas have to be revitalized to achieve the objective of people's participation in real terms. Strengthening organizational structure. Local government organizational structures have to be strengthened with sufficient manpower. Serious efforts should be made towards recruitment and appointment of support and technical staff to ensure the smooth functioning of panchayats. Comprehensive mechanism for taxation. Devise a comprehensive mechanism for taxation at the local levels. Without local taxation, Gram Panchayats cannot be held accountable. Funding. The Ministry of Panchayat Raj should monitor the release and expenditure of Finance Commission grants to ensure that there is no delay in their release. It should also be ensured that grants are utilized in a proper and effective manner. Panchayats should also be encouraged to carry out local audits regularly so that Finance Commission grants are not delayed. Question. Explain the influence of language as a divisive factor. What are constitutional guarantees given to the linguistic minorities? Diversity in the area of culture, religion, ethnic, and language is the most characteristic trait of India. This is mostly because of India's long-dated history and to be a home of varying cultures, ethnics, and religions. The historical developments have added to the diversity of India in all areas. In a multilingual society like India, many languages are used in daily life. One language may be preferred in the domains of domestic and friendship groups, another for administration and work, and a third language in religious discourse. Another characteristic of languages in India is that, generally speaking, there is no direct relations between languages and religions and subcultures. As a mix of various cultures, there is no particular language that can be considered as the dominant one across every state in the country. Thus, India does not have a national language. However, the languages spoken in various regions play an important role in the lives of people, socially and economically. In this article we shall discuss a language as divisive factor. National movement and language. During the colonization of India by British in the 18th century, English became a lingua franca and in 1835, it was made official language at both the central and provincial or state levels. However, English was not used throughout the entire administrative system. In lower level administration some regional languages were used. Since nationalists began to fight against the British colonization, the Congress Party, the leader of national movement in India, drew attention to languages of the Indians as a sign of national identity. In fact, the Congress Party had organized itself on the basis of linguistic and cultural regions. The leaders of national movement were very sensitive about using an indigenous language. Post-independence linguistics policy. Before independence in 1947, the Congress was committed to redrawing the state boundaries on the basis of languages. In 1920 in Nagpur session, Congress formally accepted principle of linguistic states. After independence in 1947, however, the Government of India chose not to implement the policy, due to very bad experience of the partition of India on religious grounds. Discussion in Constituent Assembly. The Constituent Assembly was concerned with the issue of linguistic states in India. Among the major issues debated in the Constituent Assembly was the linguistic division of India, something Nehru resisted. Other language-related issues debated in the Constituent Assembly included the national language, official language and its script. The Constituent Assembly, however, could not arrive at the conclusion, and finally the matter was left with the Parliament by the virtue of Article 3 of the Constitution of India. The Constitution of India also contemplates the provision regarding the language policy. But at the time of the constitution making, the language controversy came to the forefront. The debates of the Constituent Assembly revealed that there was a substantial amount of consensus on two basic points. 1. At some stage, the English language should be displaced from its preeminent position, and 2. Its place should be taken by Hindi. In 1948, the Der Commission was appointed by the Government of India under the chairmanship of S.K. Der. The Commission did not recommend for the creation of states on the linguistic consideration. This report created an adverse reaction in Andhra. The resistance to call for linguistic states was led by the first Union Home Minister, Sardar Patel. But after the death of Poti Sriramulu after 56-day hunger strike for demand the creation of a separate Andhra carved out of the sprawling state of Madras, government was forced to carve out Andhra Pradesh from the state of Madras. The central government of India constituted the States Reorganisation Commission in 1953 under the States Reorganisation Act to study the problems in redrawing state boundaries. The commission consisted of Honorable Fazal Ali, K.M. Panikkar and H.N. Kunzru. The report submitted by the Commission in 1955 known as SRC report. This commission viewed language as an important, although by no means the sole factor. Other factors, such as economic viability and geographical realities, had to be taken into account. Controversy over official language. The Constitution of India also contemplates the provision regarding the language policy. But at the time of the constitution making, the language controversy came to the forefront. The debates of the Constituent Assembly revealed that there was a substantial amount of consensus on two basic points. 1. At some stage, the English language should be displaced from its preeminent position, and 2. Its place should be taken by Hindi. Mahatma Gandhi and other secular political leaders preferred Hindi as national language. Having gained independence from the British in 1947, the leaders of the new Indian nation recognized the opportunity to unite the many regions of India with a common, universal language. Mahatma Gandhi felt that this was essential to the emergence of India as a self-proclaimed nation. He pointed out 5 requirements for any language to be accepted as the national language. It should be easy to learn for government officials. It should be capable of serving as a medium of religious, economic, and political intercourse throughout India. It should be the speech of the majority of the inhabitants of India. It should be easy to learn for the whole of the country. In choosing this language, considerations of temporary or passing interests should not count. The Indian Constitution, in 1950, declared Hindi in Devanagari script to be the official language of the Union. Unless Parliament decided otherwise, the use of English for official purposes was to cease 15 years after the Constitution came into effect, i.e., on 26 January 1965. The prospect of the changeover, however, led to much alarm in the non-Hindi speaking areas of India, especially Dravidian speaking states whose languages were not related to Hindi at all. As a result, Parliament enacted the Official Languages Act, 1963, which provided for the continued use of English for official purposes along with Hindi, even after 1965. In late 1964, an attempt was made to expressly provide for an end to the use of English, but it was met with protests from states such as Maharashtra, Tamil Nadu, Punjab, West Bengal, Karnataka, Puducherry and Andhra Pradesh. Some of these protests also turned violent. As a result, the proposal was dropped, and the Act itself was amended in 1967 to provide that the use of English would not be ended until a resolution to that effect was passed by the legislature of every state that had not adopted Hindi as its official language, and by each house of the Indian Parliament. Language Policy of India. According to Article 343(1) of the Indian Constitution, Hindi and English are the official languages of India. The purpose of using Hindi and English is specified in the Official Languages Act of 1963, the Official Language Rules of 1976, and Ministry of Home Affairs directives. By 2022, the Constitution recognizes a total of 22 languages as official. According to the Indian Constitution, no language has the status of the national language. 3-language formula. With a view to cement national unity and integrity, the National Integration Conference in 1961 examined and discussed the language problem and recommended the adoption of 3-language formula for secondary education all over the country. This formula envisaged the compulsory teaching of 3 languages in schools, the regional language and English together with Hindi in the non-Hindi speaking states and another modern Indian language and English in the non-Hindi speaking states. So far the 3-language formula has not been implemented in its letter and spirit. Constitutional provisions on language. Article 120 Language to be used in Parliament. 1. Notwithstanding anything in Part 17, but subject to the provisions of Article 348, business in Parliament shall be transacted in Hindi or in English, provided that the Chairman of the Council of States or Speaker of the House of the People, or person acting as such, as the case may permit any member who cannot adequately express himself in Hindi or in English to address the House in his mother tongue. 2. Unless Parliament by law otherwise provides, this article shall, after the expiration of a period of 15 years from the commencement of this Constitution, have effect as if the words, or in English, were omitted therefrom. Article 343 Official Language of the Union. 1. The official language of the Union shall be Hindi in Devanagari script. The form of numerals to be used for the official purposes of the Union shall be the international form of Indian numerals. 2. Notwithstanding anything in clause 1, for a period of 15 years from the commencement of this Constitution, the English language shall continue to be used for all the official purposes of the Union for which it was being used immediately before such commencement, provided that the President may, during the said period, by order authorize the use of the Hindi language in addition to the English language and of the Devanagari form of numerals in addition to the international form of Indian numerals for any of the official purposes of the Union. 3. Notwithstanding anything in this article, Parliament may by law provide for the use, after the said period of 15 years, of a. The English language, or b. the Devanagari form of numerals, for such purposes as may be specified in the law. Article 344 Commission and Committee of Parliament on Official Language. 1. The President shall, at the expiration of 5 years from the commencement of this Constitution and thereafter at the expiration of 10 years from such commencement, by order constitute a commission which shall consist of a chairman and such other members representing the different languages specified in the 8th schedule as the President may appoint, and the order shall define the procedure to be followed by the commission. 2. It shall be the duty of the Commission to make recommendations to the President as to a. the progressive use of the Hindi language for the official purposes of the Union. b. Restrictions on the use of the English language for all or any of the official purposes of the Union. c. The language to be used for all or any of the purposes mentioned in Article 348. d. The form of numerals to be used for any one or more specified purposes of the Union. e. Any other matter referred to the Commission by the President as regards the official language of the Union and the language for communication between the Union and a state or between one state and another and their use. 3. In making their recommendations under Clause 2, the Commission shall have due regard to the industrial, cultural and scientific advancement of India, and the just claims and the interests of persons belonging to the non-Hindi speaking areas in regard to the public services. 4. There shall be constituted a committee consisting of 30 members, of whom 20 shall be members of the House of the People and 10 shall be members of the Council of States to be elected respectively by the members of the House of the People and the members of the Council of States in accordance with the system of proportional representation by means of the single transferable vote. 5. It shall be the duty of the committee to examine the recommendations of the Commission constituted under Clause 1, and to report to the President their opinion thereon. 6. Notwithstanding anything in Article 343, the President may, after consideration of the report referred to in Clause 5, issue directions in accordance with the whole or any part of that report. Article 345 Official language or languages of a state. Subject to the provisions of Articles 346 and 347, the legislature of a state may by law adopt any one or more of the languages in use in the state or Hindi as the language or languages to be used for all or any of the official purposes of that state. Provided that, until the legislature of the state otherwise provides by law, the English language shall continue to be used for those official purposes within the state for which it was being used immediately before the commencement of this Constitution. Article 346 Official language for communication between one state and another or between a state and the Union. The language for the time being authorized for use in the Union for official purposes shall be the official language for communication between one state and another state and between a state and the Union. Provided that if two or more states agree that the Hindi language should be the official language for communication between such states, that language may be used for such communication. Article 347 Special provision relating to language spoken by a section of the population of a state. On a demand being made in that behalf, the President may, if he is satisfied that a substantial proportion of the population of a state desire the use of any language spoken by them to be recognized by that state, direct that such language shall also be officially recognized throughout that state or any part thereof for such purpose as he may specify. Article 348 Language to be used in the Supreme Court and in the High Courts and for acts, bills, etc. 1. Notwithstanding anything in the foregoing provisions of this part, until Parliament by law otherwise provides. A. All proceedings in the Supreme Court and in every High Court. B. The authoritative texts. I. Of all bills to be introduced or amendments thereto to be moved in either House of Parliament or in the House or either House of the Legislature of a state. 2. Of all acts passed by Parliament or the Legislature of a state and of all ordinances promulgated by the President or the Governor of a state, and 3. Of all orders, rules, regulations and bylaws issued under this Constitution or under any law made by Parliament or the Legislature of a state, shall be in the English language. 2. Notwithstanding anything in subclause A of clause 1, the Governor of a state may, with the previous consent of the President, authorize the use of the Hindi language, or any other language used for any official purposes of the state, in proceedings in the High Court having its principal seat in that state, provided that nothing in this clause shall apply to any judgment, decree or order passed or made by such High Court. 3. Notwithstanding anything in subclause B of clause 1, where the legislature of a state has prescribed any language other than the English language for use in bills introduced in, or acts passed by, the legislature of the state or in ordinances promulgated by the governor of the state or in any order, rule, regulation or bylaw referred to in paragraph 3 of that subclause, a translation of the same in the English language published under the authority of the governor of the state in the official gazette of that state shall be deemed to be the authoritative text thereof in the English language under this article. Article 349 Special procedure for enactment of certain laws relating to language. During the period of 15 years from the commencement of this Constitution, no bill or amendment making provision for the language to be used for any of the purposes mentioned in Clause 1 of Article 348 shall be introduced or moved in either House of Parliament without the previous sanction of the President, and the President shall not give his sanction to the introduction of any such bill or the moving of any such amendment except after he has taken into consideration the recommendations of the Commission constituted under Clause 1 of Article 344 and the report of the committee constituted under Clause 4 of that article. Article 350 Language to be used in representations for redress of grievances. Every person shall be entitled to submit a representation for the redress of any grievance to any officer or authority of the Union or a state in any of the languages used in the Union or in the state, as the case may be. Article 350 of Facilities for instruction in mother tongue at primary stage. It shall be the endeavor of every state and of every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups, and the President may issue such directions to any state as he considers necessary or proper for securing the provision of such facilities. Article 350b Special Officer for Linguistic Minorities. 1. There shall be a special officer for linguistic minorities to be appointed by the President. 2. It shall be the duty of the special officer to investigate all matters relating to the safeguards provided for linguistic minorities under this Constitution and report to the President upon those matters at such intervals as the President may direct, and the President shall cause all such reports to be laid before each House of Parliament, and sent to the government of the states concerned. Article 351 Directive for Development of the Hindi Language. It shall be the duty of the Union to promote the spread of the Hindi language, to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India and to secure its enrichment by assimilating without interfering with its genius the forms, style and expressions used in Hindustani and in the other languages of India specified in the 8th schedule, and by drawing, wherever necessary or desirable, for its vocabulary, primarily on Sanskrit and secondarily on other languages. Formation of linguistic states. The process of linguistic reorganization of states in India was far more prolonged and divisive than the controversy over the official language of India and raised more fundamental questions of center-state relations. Following the States Reorganization Act of 1956, the boundaries of the southern states were reorganized in closer conformity with traditional linguistic regions. The bifurcation of Bombay province into the present state of Gujarat and Maharashtra followed in 1960. In 1966, Punjab was reorganized and its several parts distributed among 3 units, the core Punjabi Suba, the new state of Haryana, and Himachal Pradesh. Several new states also have been carved out in response to tribal demands in the northeastern region of the country from time to time. The broad principles enunciated by the State Reorganization Commission in creating linguistic states were the following: to preserve the unity and integrity of the country, to maintain linguistic and cultural homogeneity, and financial, economic and administrative viability. Recommendations of Sarkaria Commission. In 1983, the Sarkaria Commission was constituted to look into the language problem in India and suggest measures. The commission was headed by R.S. Sarkaria. The commission made the following recommendations. 3-language formula. It included the implementation of regional language, Hindi and English at the school level education. English was to be retained as the official language. Reorganization of states into administrative units. Ban on political parties and other organizations trying to promote linguism. Constitutional provisions for linguistic minorities. The reorganization of states was done on the basis of recognized languages of India, and it placed many linguistic groups in a minority position in the states where they resided. This generated a feeling among all linguistic minorities that if they do not have a home state, they are second-class citizens, and those who get such home states started feeling that they only have the right to live and prosper in their states. Hence some provisions are done in the Constitution to safeguard the interests of 9F linguistic minorities. Article 29 Protection of Interests of Minorities. 1. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. 2. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language or any of them. Article 30 Right of minorities to establish and administer educational institutions. 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. 1a. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority, referred to in clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. 2. The state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Growth of linguism. The phrase linguistic fanaticism implies any attempt by a linguistic group or an individual to show disrespect or decry other constitutionally recognized languages or dialects or subjugate minorities on linguistic basis or preach secessionist movement in the name of language. The reorganization of states was done on the basis of recognized languages of India, and it placed many linguistic groups in a minority position in the states where they resided. This generated a feeling among all linguistic minorities that if they do not have a home state, they are second-class citizens, and those who get such home states started feeling that they only have the right to live and prosper in their states. Causes of linguism. Regionalism. Linguistic fanatism has promoted local identity. It has created distinctiveness among people. The regional differences have come in the way of national integration. Regionalism is the expression of a common sense of identity and purpose by people within a specific geographical region, united by its unique language, culture, etc. Rise of regional parties. Linguism has resulted in the formation of regional political parties. The regional political parties formed governments in several states and tried to give concrete shape to their policies and programs. At the present juncture, these regional parties are playing a crucial role in the formation of government at the center and also at some states. Most of these regional parties parley politics of language of their states. Exploitation of people by politicians. Language has evoked psychological and emotional feelings among people. Politicians are promoting the spread of only particular languages through monetary inducements. They exploit the sentiments of people at the time of election. Erosion of national feeling. Linguistic loyalty has come in the way of national integration. People are much concerned about the regional gains than the interest of the nation. Thus, interstate boundary disputes, river disputes have become common. Major events of linguism. In 1937, the first anti-Hindi imposition agitation was launched in opposition to the introduction of compulsory teaching of Hindi by the first Indian National Congress government led by C. Rajagopalachari in the Madras Presidency schools. This move was immediately opposed by E. V. Ramasamy, Periyar, and the opposition Justice Party, later Dravida Kazhagam. In 1965, as the day of switching over to Hindi as sole official language approached, the anti-Hindi movement gained momentum in Madras state with increased support from college students. In the same year, a full-scale riot broke out in the southern city of Madurai, sparked off by a minor altercation between agitating students and Congress party members. Finally, to calm the situation, Indian Prime Minister Lal Bahadur Shastri gave assurances that English would continue to be used as the official language as long as the non-Hindi speaking states wanted. Before and around the 1980s, Sanskrit would be available to learn at the high school level in Karnataka, and students chose it as it was a way to gain easy marks, and thus, a higher state rank. Then Chief Minister D. Devaraj moved Sanskrit from a first language to a third language. The next Chief Minister, R. Gundu Rao reversed this decision. With a committee under Professor V.K. Gokak, many Kannadigas began to protest against this reversal. The Gokak Committee report stated for Kannada to be the sole first language. The delay from the state to uphold this led to protests and due to it, several deaths. Question: who are linguistic minorities? Linguistic minorities are group or collectivizes of individuals residing in the territory of India or any part thereof having a distinct language or script of their own. The language of the minority group need not be one of the 22 languages mentioned in the 8th schedule of the Constitution. In other words, linguistic minorities at the state level mean any group or groups of people whose mother tongues are different from the principal language of the state, and at the district and taluka tahsil levels, different from the principal language of the district or taluka tahsil concerned. Question: are there any safeguards for linguistic minorities? The safeguards for linguistic minorities derive their authority from two sources. The Constitution of India. The scheme of consensual safeguards agreed to at the All India level from time to time. Question: which articles in the Constitution of India provide safeguards for linguistic minorities? Articles 29, 30, 347, 350, and 350A and Article 350B, and the Articles 14, 15 and 16 which guarantee certain fundamental rights to all the citizens. Question: how does Article 29 and 30 of the Constitution provide safeguards to linguistic? Article 29, Protection of Interests of Minorities. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language or any of them. Article 30, Right of minorities to establish and administer educational institutions. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority, referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. The state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Question: how does Article 347 of the Constitution provide safeguards for linguistic minorities? On a demand being made in that behalf, the President may, if he is satisfied that a substantial proportion of the population of a state desires the use of any language spoken by them to be recognized by that state, direct that such language shall also be officially recognized throughout that state or any part thereof for such purpose as he may specify. Question: how does Article 350, 350A and 350B of the Constitution provide safeguards for linguistic minorities? Article 350, Language to be used in representations for redress of grievances. Every person shall be entitled to submit a representation for the redress of any grievance to any officer or authority of the Union or a state in any of the languages used in the Union or in the state, as the case may be. Article 350A, Facilities for instruction in mother tongue at primary stage. It shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups, and the President may issue such directions to any state as he considers necessary or proper for securing the provision of such facilities. Article 350b. Special Officer for Linguistic Minorities. There shall be a special officer for linguistic minorities to be appointed by the President. It shall be the duty of the special officer to investigate all matters relating to the safeguards provided for linguistic minorities under this Constitution and report to the President upon those matters at such intervals as the President may direct, and the President shall cause all such reports to be laid before each House of Parliament, and sent to the government of the states concerned. Question: what are the consensual safeguards for linguistic minorities arrived at in various meetings? The scheme consensual safeguards includes provision for the translation and publication of rules, regulations, notices, etc., in minority languages in areas where their speakers constitute 15% or more of the local population, declaration of minority languages as second official language in districts, where their speakers constitute 60% or more of the population, receipt of and reply to representations in minority languages, instruction through mother tongue at the primary stage of education. Instruction through minority languages at the secondary stage of education, advance registration of linguistic preference of linguistic minority pupils and inter-school adjustments, provision for textbooks and teachers in minority languages. Implementation of three-language formula, regional official language not to be a prerequisite for recruitment to state services. Setting up of proper machinery for implementation of safeguards for linguistic minorities at the state and district levels, and issue of pamphlets in minority languages detailing safeguards available to the linguistic minorities. Question: with whom does the basic responsibility for implementation of safeguards vest? The basic responsibility of implementation of the safeguards for linguistic minorities rests with the state government's UT administrations, who are required to appoint nodal officer for linguistic minorities. Their active cooperation, therefore, is the key to safeguarding the interests of linguistic minorities. Question: what is the role and function of the Commissioner for Linguistic Minorities? The Constitution of India under Article 350b, 1 and 2, provides for Special Officer for Linguistic Minorities formally designated as the Commissioner for Linguistic Minorities in India, CLM. Article 350b was inserted in the Constitution of India because of the Constitution, 7th Amendment, Act 1956, consequent to the acceptance of the recommendations of the States Reorganisation Commission, SRC, by the Government of India in 1956. The CLM looks after the interests of the linguistic minorities, as distinct from religious minorities SCs, STs, OBCs. Basic function of the CLM is to investigate all matters relating to safeguards provided for linguistic minorities and to report to the President of India upon these matters at such intervals as the President may direct. The President causes all such reports to be laid before each House of Parliament. Besides, the CLM may prepare reports on vital issues and submit these to the Union Government and to the Chief Ministers, Lieutenant Governors of the states UTs concerned. The CLM organization works under the administrative control of the Union Ministry of Minority Affairs, Government of India. Question: how does the CLM organization work? The CLM organization takes up all matters relating to the safeguards for linguistic minorities brought to their notice by the linguistic minority individuals, groups, associations, organizations. The CLM organization is in regular touch with the state governments' UT administrations to ensure the implementation of the scheme of safeguards for linguistic minorities. The CLM personally visits linguistic minority areas and educational institutions for an on-the-spot assessment of the status of implementation of the scheme of safeguards. In this connection, the Commissioner holds discussions when required with the chief ministers, governors and lieutenant governors of the states, union territories. The CLM also holds discussions at the highest levels of administration with Chief Secretary, Principal Secretary, Education, and Principal Secretaries of the departments entrusted with monitoring the implementation of the scheme of safeguards for linguistic minorities. The Deputy Commissioner for Linguistic Minorities, DCLM, Assistant Commissioners for Linguistic Minorities, ACLM, and Research Officer, RO, of the CLM organization also visit places areas where speakers of minority languages are in sizable number and hold discussions with the district authorities and their officers with a view to resolve problems of linguistic minorities.